Just respond to the objection.
Sure. To the objection is, I think I'm essentially responding to your question because you asked me why I'm saying there was a conflict of interest. And what I'm trying to convey to the panel, it's all the pertinent information, contextual information that makes the panel understand the conflict of interest that has been in the Department of Health from the very beginning, because the Department of Health, because of failures in the inspection, has been responsible in part for the problems that were present in the hospital.
Okay, so what I would tell you, sir, is with all due respect, the Department of Health is not on trial here this morning. You are.
Sure.
So I will accept the explanation that you've provided insofar as you've told me that your conflict of interest arose because of your disagreement with the information concerned in the Quincy Valley Medical Center fire report, fire inspection report. I will accept that as an answer. And I don't think we need to go any further. Much more detail starts to take you into those exhibits that I've already ruled in other concerns.
Sure.
And I have no other questions for you. But Ms. O'Neill, did you have any redirect?
No, no.
Okay.
Ms. Smith, aside from the philosophy, aside from the conflict of interest, aside from everything else that had happened before you were ordered to get a mental health exam, what did you view as the downside at that stage to getting the ordered mental health exam?
That's a great question. You know, and essentially, I am sorry, but I have to go to a matter of principle. The unreasonable imposition is not something that is appropriate.
But again, assuming that the law, I mean, you had a lawyer at some point, assuming the law requires you to do it, and that the Department of Health, whatever conflict it may have had, is going to pay for it.
Correct.
What's the downside to getting it? As far as you're concerned, keep it narrow, keep it focused, if you would.
Sure. I had 4 mental health evaluations done since this procedure started already. I have no issue whatsoever in getting 4 more, if they're deemed necessary and they are at the end imposed on me because I have no option. There is no question whatsoever. The reason why I refused to comply with the way things were presented here was a matter of principle, and the imposition, just because I say so, is not something appropriate for a 43-year-old professional that has been a physician for 20 years.
Yeah, no, so you're just saying I shouldn't have to do it.
I gave plenty of arguments to the fact that the order was not appropriate.
Right.
Yes, correct.
But you shouldn't have to do it, as a matter of principle, based on everything that had happened before then.
Based on all the evidence, everything that has happened before, that is correct.
All right. That's all.
Thank you. Ms. O'Neill, any other witnesses for the department?
No, the department rests at this point. Then.
Thank you. Dr. Cornu-Labat, did you have witnesses that you wish to call?
Yes, I do. I wish to call Dr. Robert Fink.
Dr. Alessi, raise your right hand. Do you swear or affirm that the testimony that you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Your Honor, at this point, the department objects on the basis that this witness doesn't have anything to offer in terms of whether Dr. Cornu-Labat has gotten or failed to get the examination that the commission ordered. He's one of the providers that examined Dr. Cornu-Labat at his own request. under the terms of the statute, his findings are entitled to be submitted to the commission. They were in fact before the panel that ordered this examination, but by statute, no number of examinations that Dr. Cornu-Labat gets on his own is a substitute for the commission-ordered examination, and I object to the witness's testimony because I don't think it's relevant to any issue before the commission.
Doctor, your response.
As I argued on my opening statement, if we are going to be arguing about the letter of the law, or we are going to be arguing about the purpose and intent of the law, which is what I intend to bring forward. The reason why I asked Dr. Fink to be present as a witness today is because I want to show the panel that I have complied with ample margin to the need of proving that there is safety on a healthcare practitioner when a doubt is raised. And this is the reason why I'm presenting him as a witness. And if we're going to be arguing that I did not comply with this particular order, and I'm not going to be allowed to argue any further than that, then the whole thing is already decided. And the important thing, what we don't have to forget here, is that the mandate of the Commission is public safety. And the issue from the very beginning has been if I am safe to practice medicine or not. And this is the core intent of this order that was issued on the 22nd of September of last year, and that is in question right now. And Dr. Fink is here to prove to the panel that that need that the Commission has to fulfill has been fulfilled without delay.
And the objection is that at this point, nothing that Dr. Fink can offer is relevant to the decision this panel needs to make. The fact that Dr. Cornu-Labat had gotten his own examinations is before the Commission. It was before the panel that ordered the examination. Dr. Fink's report was part of the written documentation submitted to that panel. There is simply nothing he can offer this morning on the question of whether Dr. Cornu-Labat has complied with the Commission's order that he get the specified examination.
May I?
Yes, sir.
It was part of the evidences I've submitted, and that the panel that considered these never even had the consideration of explaining why these had not been valid, because these were part of the initial report. I don't know how much the panel is aware that this whole issue started as a self-report that I brought up to the Department of Health, to the Medical Quality Commission.
You instigated.
I initiated, I brought up as a self-report, and I brought up the fact that I had been accused. At the time, I did not know the content of the accusations because they were never shared with me. I brought up all the issues I had done to address those accusations, and I even brought up the evidence to explain why those accusations in the first place had happened. I gave a motive and a modus operandi for the whole process. From the very beginning, this whole case started as an initiative from me to put myself in front of the Commission, to seek justice, to seek an understanding of an issue that is of significant pertinence to the public. From the very beginning. Now, certainly, the Commission, according to Ms. O'Neill, gave me a chance to present my side of the story. But eventually, out of all the efforts I did to present over 30 testimonies that completely contradicted what was presented before, I'm just told You have to do this. Why? You have to do it. Because I say so. This is what I refused. The disrespect implied in something like that. And we all know very well what a mental health evaluation can mean. And a mental health evaluation, which is, I mean, if somebody's telling me I have a neurologic deficiency because I'm limping, that's a very concrete thing. Mental health is so fluid. We can be dragging with personality issues for months. And if my concern about a conflict of interest would happen to be true, well, then suddenly I would be dragging, or at least I would risk being dragging for a while.
Well, two things. Issue number one, as to the department's objection. Doctor, there's a process in the law that speaks to something called an offer of proof. I believe that the department's objection is correct. That, with all due respect to the good doctor, that his testimony is immaterial to the simple question, did you comply with the order? If you were an attorney, or even representing yourself, you're allowed to make something called an offer of proof, but I will tell you, sir, what that would mean is you would ask questions of this witness. Ms. O'Neill would be given an opportunity to ask other questions, and the reason you'd be doing that is you'd be making a record in the event you choose to appeal this decision, whatever the commission's decision is, and I have no idea what it's going to be. Although the law might suggest the outcome. But that offer of proof would be done outside the presence of the commission panel. The panel members wouldn't hear you asking the questions of this doctor. Because that's the way the law is. That's evidence that they would not be allowed to consider because I'm ruling that it's not material or relevant to this particular case. And I again remind you, probably more times than you wish to hear, it was a very simple hearing at this point. You've undergone two proceedings before the commission. One in which you were permitted to submit a large amount of evidence in written form. And this proceeding in which you can only present documents, evidence that speaks to whether or not you've complied with the commission's order. And I cannot mix the two hearings. Even though you might want me to do so, I cannot do so legally. And I will not do so. So I will, unless you choose to make an offer of proof, I will ask the good doctor to step down from the witness stand and we will proceed further. You wish to make an offer of proof, sir?
Which will allow me to, in the record.
You would make a record outside these four commission members.
I don't think at this point it's relevant. I think the importance of Dr. Fink was for the commission, for the panel to consider and to understand the whole scope of what is at stake today. Even though I understood from the very beginning that we would be, or the department would be trying to limit the argumentation to the very narrow idea of or facts, if I comply or not with